All right, we're going to go ahead and get started. Once those that are will come online, we will acknowledge those that will have joined. Um, Ms. Ham, if you would give the introduction and let us know how we will proceed.
Yes, sir. Thank you, Reverend Matt. Can everyone on Zoom hear me? You can just nod. Okay, perfect. So today we're facilitating the procurement workshop for the CCSD Board of Trustees. The first part of the presentation will be done by Mr. Lawrence and Mr. Pat Flynn. They are two attorneys, one based out of Columbia, one based out here in Charleston. They're going to give a presentation and allow for questions to be asked. Okay. How about that? A little better? Okay. And allow for a time period for questions. And then after that, Mr. Kennedy and his team are actually going to give an overview of the CCSD's actual procurement process and allow questions at the end of that. And so with that, I am going to turn it over to Mr. Lawrence Flynn.
Thank you, Natalie. I hope everyone can hear me. I'm usually a fairly loud talker, but if you can't, make sure y'all ask. So my name is Lawrence Flynn, and with me is my uncle, Pat Flynn, and we are with Pope Flynn Law Firm. I'm based out of Columbia. Like Natalie said, Pat is based here in Charleston. Our law firm is a boutique practice. We kind of started, the three of us broke off from a large law firm back in January of 2008. Doing public finance and governmental work, so bond issues mainly, and have kind of moved into more general governmental work as our practices continue to evolve. The thinking behind it was we only represent local bodies. We typically have never sued people. I tell people all the time I'm not a real lawyer because I just read contracts and and try and keep people out of trouble. And for the longest time, that's the way we operated. And the kind of the best part of that is you travel around the state. I considered myself a kumbaya lawyer. We would, raise people's taxes, move on to the next place. And as we kind of continued to evolve the practice and added lawyers, Pat joined us about 5 years ago because we recognized that while we don't do any litigation, generally speaking, we needed some litigation counsel within the firm. Pat's practice was kind of a seamless transition for us because he does construction litigation, which is kind of the nexus with procurement piece of a lot of the work that we do. And so doing the governmental work, in order to be able to do bond work, you got to understand FOIA, you got to understand general meeting practice, you have to understand the Constitution, and then obviously you have to understand budgeting, and then that ultimately leads to procurement because all the facilities that you're building ultimately are going to be driven by a procurement process. So just by way of background, that's the way we look at things. And so the plan, I think, for the next hour is I'm going to give kind of a brief overview, as brief as I otherwise can be, of kind of the history of what the Charleston School District is, school districts in general. And the reason I think that's really beneficial is because the powers that you have today, things that you do as an organization and a board of trustees, importantly, is all driven by the Constitution and the statutes that have created this organization. And deriving from that particular authorization is how you make decisions, how you make policy. And so as we kind of start really broad and we'll start winnowing that down, that ultimately gets us to the question about particular policies, and we'll ultimately get into procurement. And Pat's going to talk through kind of the practical management side of making sure there's not legislative overreach into procurement. Some of the kind of war stories that he's dealt with in his years of being a construction litigator. And then we'll certainly cede the floor over to y'all's procurement management team because they know the brass tacks. They're here every single day. They're doing the active management and the procurement of goods and services for the district. And that's obviously the important function of the conversation that they're going to have. What I'll say, and I know it's a little bit disjointed with some people over Zoom and some people here in the room, but this is ultimately meant for y'all's benefit. So as members of the board, I like to be interrupted. So y'all, if you have a question, if we say something that you think needs a little further investigation or something that may be applicable to your particular situation. We're here to be a sounding board for you. Our goal at the end of the day is to make this a training session and be as productive for your time as you want to make it. And so with that, I don't know who my slide person is. Hey, Maggie, if you would flip to the next one. Okay, we can flip to the next one. So just a little bit of brief history, and I think most folks that are on the board know this. So the school district historically was operated as 8 independent districts, and that was not unique. In South Carolina, under our original 1895 Constitution, which is still the directive by which we operate today, it's been amended a few times, most recently in the mid-70s with respect to some financial authorization, but we operate under the 1895 Constitution. And under that original Constitution, there was a responsibility for providing free education to the students of South Carolina. And the weird kind of way that things evolved is most schools in the beginning basically would create a district every time you created a new school. And so you still see this in Spartanburg today. Spartanburg still has 7 school districts. Y'all at one time had 8. And by this special act in 1967, you were consolidated into this nine-member board of trustees, and you maintained the constituent districts to be able to do the day-to-day operations of those ancestral district areas. And so that's still the way that you're structured today. Obviously, y'all understand that process. Maggie, if you'd flip to the next one. Same kind of idea there. I know that there has been some discussion about the board constitution changing and that election process. You're going to probably hear me say some things today in the discussion of constitutional powers with respect to school districts that may even lend some question as to the validity of the legislation that made this change, but that's for a different day, and I can kind of drop that grenade and walk on out. Maggie, if you flip to the next one. So the one thing I want to make sure, and this may seem a little bit out of place, but one thing that's always really beneficial that I like to point out to especially new members of a board is that you are serving in a position of honor or profit under the Constitution. And so that generally means that you can't serve in more than 2 of those positions at a time. Actually, Natalie's role as the chief legal officer, the reason that she can't, I know we're all disappointed to see her go, but she starts her new position with Charleston County on Monday. She can't both serve as the chief legal officer to the Charleston School District and the Charleston County, as much as we all know that she'd have that ability to do so, because the Constitution prohibits serving in a role of honor or profit over the time. So if you actually accept that new role, you're deemed to have resigned your existing role. The reason I bring that up, because it also brings in this idea of master-servant responsibility. And the master-servant restrictions that have kind of evolved through time under the dual office holding restrictions are the idea that we're going to talk about here in a minute, is that your role as a board of trustees is to serve in a legislative capacity, to make decisions on the operation, to pass legislation for how this organization operates as a body politic. The reason that that's important is because in your role as a decision maker in setting policy, you couldn't be a member of the board and the superintendent. You couldn't be a member of the board and a principal. You couldn't be a member of the board and a football coach, because you would be setting policy that would directly affect the day-to-day operations of that individual as a staff member. And the reason I bring that up, and that's an important concept, is because when you set policy and you make a decision as to how the district is going to organize, when you get involved in the day-to-day administration of the operations of the district, it starts to infringe on that master-servant relationship, because at the end of the day, this organization's sole employment responsibility outside of signing contracts for teachers and other staff members is to employ the superintendent. That is expressly laid out in your statutory authorization, and it's part of your kind of constitutional construct. That is your role with respect to employment, is the engagement and the hiring of the superintendent. So Maggie, if you flip to the next one. So what are those powers, Maggie? So generally speaking, school districts are a lot like special purpose districts in South Carolina. You operate a little bit differently than cities and counties do, and that's a relatively new phenomenon. I say new in the sense that it was before my time, because the Home Rule amendments to the Constitution came in the early 70s. Because historically, all local governments, so cities, counties, special purpose districts, school districts, all derive their powers directly from the Constitution and then general enabling legislation granted by the legislature that gave you particular powers to operate. And that function is known as Dillon's rule historically. So as a local government enterprise, you were a Dillon's rule entity, meaning that you only had those powers that were granted to you expressly by legislation. In cities in particular have always had additional powers under the 1895 Constitution, but we knew that for sure through the amendments to the Home Rule Act, or the institution of the Home Rule Act in 1973. And in 1973, the Home Rule Act was amended, and that basically said, with respect to counties and cities, we're transitioning the power. The Constitution is going to be seen as a broad grant of power to cities and counties, so they can do all of those things to operate from home to make their operations. Now, there's still some restrictions on fiscal autonomy, levying taxes, but you can police, you can provide fire, you can do all those things. And you can make that kind of mandate from the city council or the respective county council. Special purpose districts like the Charleston Recreation District or school districts like yourselves didn't receive home rule powers. And so you are still Dillon's rule entities. You are restricted by the terms of the Constitution. So you can't act outside that authorization. That applies to all cities, counties, special purpose districts, what have you. But you only have those powers that have been expressly given to you by the legislature. And so what you have to look to then are the pieces of special legislation that originally were the way that you operated. And the kind of seminal piece of that legislation is your legislation that consolidated and created this board in '67, which was obviously before the Home Rule amendments to the Constitution, that specifically laid out your power. And then on top of that, we now have Title 59, which is the general law giving power to school districts in general, and then a whole smattering of other laws that we've come to kind of recognize as effective. So that's budgeting responsibility and FOIA and bond issuance authorization. And we can touch on some of those in a minute as well. Maggie, if you flip to the next one. So I'm not sure if this is hard to read or not, but at least we can kind of check the box. Up there in the upper right-hand corner is a screenshot that I took. This is, I don't know if anyone can see it, but for people that are at home and are looking at the video, there's a big set of code books, and each piece of special legislation from 1895 forward is codified in a book that gives you your particular authorization. And so these particular powers are also given to you directly at the time that you receive the consolidated action to create this district. And so when you consolidated the district, the 9 of you became the board of trustees. The legislature also said, well, we're also going to give you all of these powers in order to operate. And this is before the general directive of Title 59 came into effect to kind of overlay on top of it. And you'll see what was kind of granted. It's the same things that you do today. You appoint a superintendent, you adopt a corporate seal, you add and adopt and publish policies and procedures, you adopt a budget, and you'll see the last one because I italicized it, establish and maintain a purchasing system for the purchase of all contractual services, equipment, and supplies pursuant to rules promulgated by the Board of Trustees. So in the 60s, even as far back as the creation of this organization as a governing board, it was recognized that not only do you budget, but you also need to put in place policies and procedures with respect to how you procure and spend public dollars for the purchase of goods and services. So Maggie, if you go to the next one. Now, that general enabling legislation, which is that 67 Act, has to now also be read in concert with the provisions of Title 59, which is the general education statutes that have been promulgated by the legislature, largely in the aftermath of the Home Rule amendments. And so these are the direct powers that are provided in the Title 59 provisions. And you'll actually see a lot of them actually overlap with your general powers under your enabling act. And so you see provide for schoolhouses, to employ and discharge teachers, to visit schools, to establish a calendar, to prescribe attendance requirements. So some of those are in addition to the powers that you otherwise have. Some of them are the same, and some of them are probably in direct conflict with powers that you had under your enabling act. And the general rule of thumb with respect to conflicts between legal provisions is that a specific law trumps a general law, but a law written after a prior law trumps that prior law. So even though this is general legislation, it came in after your general enabling legislation, it's deemed to preempt authorization. So the perfect example of that is you had general bonding authority, the ability to borrow money in your 67 Act. But now Title 59 specifically provides for the ability to issue bonds. And so the state has effectively preempted your rights with respect to how you borrow money on a going forward basis. So I say all that to say, you got the Constitution, you also have your general enabling legislation, which you can still operate under today. And you then have all of these general laws that you also operate under, which all of which give you budgeting power, the ability to hire and fire a superintendent, the ability to promulgate rulemaking authorities, so policies and procedures, and that would obviously include the ability to institute procurement responsibilities. So Maggie, if you flip to the next one.
I have a question. Do you have this document in the form of something I can put in my hand?
I do not have copies with me, but I can certainly get them to you.
Would you please?
Yes, ma'am, not a problem. We can make sure that, Natalie, I'll make sure we get them back, or I can send down copies as well. Excellent. So we mentioned a few minutes ago, so you have your general enabling legislation, you have the general provisions of Title 59, and then these are just all the kind of other smattering of things that you have to think about. So we obviously have to adopt a budget by the particular terms of state law. There are particular restrictions on how you invest the money of the school district. There are restrictions on how you invest money in the state government pooled investment fund. Obviously, everyone recognizes that you're subject to FOIA, how you issue debt. And then there are also very specific provisions in Title 59, as well as Title 11, which is the general state administration provisions on what your procurement code needs to look like. And so the reason I bring that up in particular is because we've got all this authorization originally that says, hey, you have rulemaking authority. You also have the specific authorization to promulgate rules and regulations around how you create procurement responsibility. But then the state has expressly preempted you and said, we have a state procurement code. You as a school district are required to follow the terms of the state procurement code. And if you don't, you got to come and get it validated by us. That's not the way it works for all school districts. If you're the city of Charleston or you're Charleston County, the same provisions of 1135, 5340 or 5320 actually state specifically that other local governments outside of school districts are only required to create policies of effectively competitive procurement. But you as a school district are expressly preempted and have to generally conform to the terms of the state procurement code. And y'all are generally in line with that, subject to some approval by the state fiscal accountability authority. Maggie, if you flip to the next one. So in setting policy, so we've kind of laid the construct for what the Constitution has given you, the powers that you then have as a board. But as you exercise those powers, there are limitations that affect your ability to operate as a governing body. Each one of you acting alone is just a member of this community. It's only when you come together and constitute an operational quorum that you can take action to set policy as an organization. And so I think the important thing that if y'all get out of this today, you've got some regulations that we'll cite to here in a second, that are probably the most important consideration that you take away is what is your role as a body? Well, you are a legislative organization. You set the policy and the directives within the limits of the Constitution and the laws that have been given to you for how this board operates and how this organization operates. So you create the what and the why of issues. And then the staff run through your superintendent is responsible for deploying those policies and implementing them at the staff level. And at the end of the day, if council the board as a body whole is five out of the 9 of you is unhappy with the way that the direction of the policy is otherwise being implemented, that responsibility ultimately lies with Dr. Postlewaite, that this is her responsibility to administer the policies and procedures that you have set out as the directives for the organization. But that is the natural break point between legislating and administering. And that is a hard thing sometimes when you've come in from being on the outside looking in. When you're setting policy, you want to really get in and roll up your sleeves and solve the day-to-day operations, but that's not your responsibility as members of the Board of Trustees. Now you can flip to the next. So what are some of the policies that you could generally otherwise think of? Well, the first one obviously is you have a budget policy. You think through, you talk with your CFO. I assume you're probably working through the 2022 budget cycle as we speak. If you haven't already had multiple budget meetings, those are obviously on the horizon in order to be able to have your fiscal 22 budget in place by July 1. Obviously, most folks are going to have a FOIA policy. You're going to have policies on financial management. And actually, this organization, if you go on board docs, there's a direct link from your website that you have enacted, and versions of your board prior to you have enacted lots of these policies that are actually recited here, and even more than these, about the day-to-day operation of lots of things associated with the function and operation of a school district. And so, those things can be updated regularly. That is a decision that, as you come in and you get your feet wet, especially for the newer members of the board, read through those policies and make sure you have a full understanding of what you've already given as directives to the organization. That is your role and responsibility as a member of the Board of Trustees. And so these are just some general things that I point to as being policies that if you don't have are worth considering. If you do, they're at least worth making sure that they're regularly updated. Maggie, if you flip to the next one. Okay, so here is actually a screenshot from your Board of Trustees, and it actually is almost an explicit recital of what we were talking about earlier with respect to the limitations you have under the Constitution. And it says the board's powers. Man, my eyes are not good enough to be able to actually read that from here. I would like to pretend that they are, but let me flip through my slides here because I don't want to misstate it. But the board's powers are derived from the state constitution and the acts of the General Assembly, and consequently, the board may only perform those acts for which some authority exists. And so, for example, if the board decided tomorrow, yeah, we don't really like the way that property taxes are administered, for our organization. We know that we get our penny sales tax reimbursement from the state. We know we can still put on our debt service millage. We know we can still apply operating millage to 6% property holders, but we don't really like that. We're going to come up with our own millage system. You can't do that because the Constitution and the laws of the state have preempted you from being able to maintain and operate fiscal autonomy as the way you operate. So at the end of the day, folks that come onto the board say, well, we really want to change the way we operate from a financial management standpoint. And your CFO would probably tell you, well, at the end of the day, we kind of have three legs of the stool. We get our local funding through ad valorem property taxes. We get money from the state, and we get money from the feds. And we don't really have a whole lot of control over what those additional sources are over and above the per pupil costs that we otherwise are responsible. There's some discretionary fees and other money that comes in. But there's not a whole lot of flexibility in that. You are restricted by the terms of the Constitution and the laws that you have in effect for what you can ultimately do. Now, if you flip to the next one. So here is actually a policy that y'all have in place already on your own board powers. And the very first one is the board is the policymaking body of the district. Policy should be put in written form and continually reevaluated in terms of changing needs and functions of public education. So this is actually a ratification or a codification of the specific powers that we've already talked about in Act 340 and in Title 59. And you've specifically recited those by board practice and policy in your policy BBA, board powers and duties. And so the policymaking one is obviously what we're starting to winnow down on is identifying what it is that you do as an organization. Maggie, if you flip to the next one. So I flipped to this next one because it's kind of an important consideration that this board, from an ethical standpoint, has, and I say this board because obviously you're a continuing body despite having new people on it. But you have this express policy in place, which I think is a really important one. It's policy BCA, Board Member Code of Ethics. And it was adopted back in 2017. And it says very explicitly, a board member shall honor the highest responsibility that his or her membership demands by doing the following. I've highlighted it. Understanding the basic function of a school board is policymaking, not administration, and accepting the responsibility of learning to discriminate intelligently between these two functions. And then it goes on to say, we need to recognize that the authority rests with the board as an entire body, and that no individual member has a legal status to bind the board outside of their meetings. And that basically is saying, No person who is elected to this board is any greater than anyone else. You can only act in a duly called meeting called under FOIA by an action that is properly put on the agenda for consideration and action by the board. If you act outside of that authorization, it potentially could create some liability, not only for the district, but also for you personally. And we'll talk about that here in just a second. And so we've got some particular conflict language. Maggie, if you flip to the next one. Everyone's generally aware of what those conflicts are, but I wanted to at least make sure we pointed them out. That you obviously can't use your position as a member of the board for personal gain. And that means you or your immediate family, and you can't participate in decisions that affect you or something that you have a personal gain in. And I mention that because that is a fine line. Not even if you don't explicitly fall sometimes within the parameters of the ethical limitations under state law, sometimes the appearance of a conflict can be as bad as the actual conflict itself. Maggie, you go to the next one. And so this is about making sure that you obviously, you're not performing official functions in awarding contracts, anything you have to do with procurement that you have an actual interest in. So in even approving things in the budget that you may have a particular interest in, if it affects you or your immediate family, there's going to need to be a recusal for something along those lines. And your board policies already reflect that. Maggie, if you go to the next one. So I bring this up before we actually kind of delve into the particulars of the procurement code, and Pat talks about some of his war stories, is the potential for liability that it creates for you. Because a lot of this, I can talk through the history of it. We can kind of talk through the rough edges of what the concern is. But where it ultimately rests is that you, as members of the Board of Trustees, are ultimately protected. If you're acting in your decision-making capacity as a member of the Board of Trustees, you are protected from the actions that you take under the South Carolina Tort Claims Act. A tort being a violation that creates an injury against someone. And South Carolina generally has this principle that says we had a longstanding practice of what's known as sovereign immunity, which means that the state is immune from suit from third-party providers. Well, the 1895 Constitution actually removed that sovereign immunity limitation and said, no, the state actually can be sued, but only in some very limited situations. And so what they did was they removed sovereign immunity, and then they instituted about 40 different kind of subjective standards. You can call them objective, but they're ultimately going to be determined by the courts as to the reasons that you could be sued as a board or as an organization. And those protections are generally going to be in place so long as you're acting within the scope of your official duties. The problem that you get to when you start moving outside, and the reason we kind of showed all of that information earlier on the policy function and your responsibility as a board member, is that your policy responsibility or your governance responsibility is to set policy. When you start getting involved in the day-to-day operation of the organization, you're no longer fulfilling your function as a board member. You're acting outside the scope of your duties. And that very possibly could subject you, not only the district itself, but you personally to liability for the actions that you take. So if you go and meet with someone who's a contractor on the side who happens to be a friend, when you know you have a major bond issue coming up, and you have hundreds of millions of dollars potentially on the line that could be tied in for that project, and you're meeting with them and you say, yeah, don't worry, we'll make sure there's a place at the table for you. That's not a board decision. And so you have then acted, and did you create some type of civil conspiracy? Have you violated some other contractual provision, which, by the way, contracts would fall outside the limitations of the Tort Claims Act. But those are very legitimate possibilities. And I've kind of recited a list of some things where members of boards have been expressly stated, in school boards in particular, for defamation purposes, for acting in an underhanded way to try and get the superintendent fired, for actions associated with election proceedings, where in that Sanders versus Prince case, it was determined not only are the board members individually liable for their actions in trying to oust the superintendent, but the jury came back with a $4 million verdict against the board members in their personal capacity. That's a really, really scary real life event that no one that's a member of this board otherwise wants to go home and say, yeah, where am I going to come up with this $4 million to pay this off? Now, eventually that was remitted and the court reduced the number, but I'm sure there were some sleepless nights from those members of the board acting outside the scope of their official duties. Now, that went beyond acting outside of official duty. There was actually acting with fraud and malice, but it shows that you can reach all the way into the organization. The other one that you also see is outside of South Carolina law, there is the potential to collaterally attack actions of the organization through federal law, through a 1983 action for some type of civil conspiracy, for discrimination, and some violation of civil rights. All of those are also on the table. And so I point them out to say, this isn't just paying lip service to your responsibilities as a member of the board, but there are very specific and finite problems that you can create for yourself by acting outside the scope of your authority. I get you go to the next one, which gets us to the procurement code. So it only took us 30 minutes to get into the discussion of what we're actually here to accomplish today. Yes, ma'am. And so my general thought on that is, if you'll go to the next one, Maggie. So this is actually a copy of your procurement code as it's shown on your website. And these are the particular sections of state law that provide for your procurement code to otherwise be enacted. And I alluded to them a little bit earlier. There's a provision of Title 11. There's a provisional Title 59. And it basically says, as a school district, you are responsible for administering yourself in conformance with the terms of the state procurement code. And that state procurement code is then going to direct all of the procurement of goods and services within the district. Now, the district does not actually have a codified version of the state procurement code as its version. What it actually has is an offshoot of that that has been subsequently or previous received prior approval from the Budget Control Board previously, which is now the Department of Administration through the State Fiscal Accountability Authority. But you have a letter, and that's what the screenshot at the very bottom of that frame is, from the Budget Control Board at the time, now the Fiscal Accountability Authority, that says, we recognize that you have a procurement code. It's not explicitly in conformance with the state, but we approve and validate the terms of your procurement code for purposes of undertaking procurement and the functions of procurement within the district. And that is the policy that you have adopted as a board of trustees, is the 2011 version. Should you get into the procurement code and you say, you know what, we don't like this provision, we want to change this, we want to set higher limits, we want to give discretion to someone else, you have that policy-making function. The problem with that is, remember, while you have the ability to set policy, procurement has been preempted by the state. And so that oversight is that any changes that you make to your procurement code have to immediately go back to the state for approval of any of those changes. So your 2011 version that you operate under currently has been expressly approved by the state. And for you to make changes to it, unlike lots of other policies that you have, if you decide to change your bylaw, your procedural rules, or your process for implementing your budget process, or your hiring practices, those are all things that you can do at a board level, and you can make those decisions. If you want to make a change to your procurement code, you can do it, but it's going to require the oversight and approval of the state before it's valid and otherwise authorized. Does that make sense? You go to the next one for me, Maggie. So this is kind of the general provisions of your procurement code, and I'm not going to get into the actual in-depth analysis of the particular provisions. We'll let staff do that in their time when they go through the particular functions. But the one thing I will kind of point out as a result of your procurement code, there are some purchase thresholds, and the purchase thresholds are obviously important because they're going to tie back to your budget. But I think if there's a couple of things that you take away from kind of this historical analysis of the powers of the board, is that while you have powers to make policy and to set policy, your functional operational responsibilities with respect to procurement don't really lie within the procurement code. You won't find anything in your procurement code that says the Board of Trustees has an authorized purpose to sign off on this procurement or the acquisition of this piece of equipment, or even certain of the higher level of purchases authorizations. Where your direction with respect to procurement comes in at a much earlier time. It's right now in approving the budget. When you make a decision to allocate funds or appropriate funds for a large project, especially now when you think, a new high school costs $150 million, that's not a decision that you make lightly, obviously. And when you have 75, 80 facilities under management, I may be undershooting that number, but when you think, every one of those has multiple HVAC units, each one of those has a roof, all of a sudden the the day-to-day capital just management side of making those purchases is a budget function, not so much a procurement. The procurement becomes the tail wagging the dog when you've already made the decision to allocate funding for those projects. So if you have a particular issue with how procurement's really being done, the way you solve that as a board is to make sure you dig into the budget and feel comfortable with the numbers that are being allocated to acquire whatever facilities that you want. And so with that, I'm going to cede the floor to Pat and have him add, kind of some commentary on his kind of practical experience as a construction litigator and what he's seen. Yes, ma'am, Dr. Fraser.
I have a copy of the Charleston County School District Consolidated Procurement Code. And in there, section 540.2 talks about the oversight by the Board of Trustees. Are you familiar with
So
that section?
540.2. So my understanding is, and Natalie, feel free to interject, is that there is a procurement review board that is otherwise implemented to review challenges or appeals to procurement methodology. And I may have misspoken when I said that you don't have any responsibility. There is a limited responsibility of the Board of Trustees to appoint one member to that procurement review panel. Another member is appointed by the chair, and another member is appointed by the vice chair, to be able to create a 5-member review board that then makes determinations and decisions on appeals for procurement challenges. So that's only going to be in the event of a limited challenge. And I've not been through your procurement review board process before. Pat, you may have actually been through it.
I have.
From an outsider standpoint. You could probably talk through it.
Yeah.
I know Natalie is obviously very familiar.
Okay, well, I have a question about 540.2, the oversight by the Board of Trustees, and we'll get to that once we hear.
Yes, ma'am.
Because I'm very interested in the procurement process of the district. So we'll get to that. I'll let him go ahead
Okay.
and finish up.
Okay. Well, thank you, Lawrence, and thank you for the question, and certainly you can interrupt me at any time because I'm going to go through and Lawrence wanted me to go through my entire 30-year career of construction and procurement law in about 10 minutes. So it's going to be kind of a high-level overview, but I wanted to start out with some good news. What's the good news here? Charleston County School District has an excellent procurement code, and it has a highly functional staff, in my opinion, just sort of coming in and as a guy who has spent his career looking at these sorts of things from all different angles. I find that you've got a very engaged staff that knows what they're doing, and under the supervision of the superintendent and the board. So the board should take some pride in this as well. So that's the good news. Now, the rest of it is bad news. No, I'm just kidding. It's not bad news at all. Let me sort of give you my overview of what I would think that you would need to know, sort of in your the index card version of what you should know. Taking a sip of water from a fire hose is what we used to call it in the Navy. So competitive sealed bidding is required under the procurement code for projects over $50,000. So if there is a requirement that the district wants to build a new elementary school and it's going to cost $20 million now, and I'm also dating myself because I remember early in my career I was thinking that it would cost $3 million for a new school, and so that's just kind of continued to creep up. But in any event, so that's the key to this procurement code is competition, fair competition, and responsible and responsive bidders. Now, there are a number of different things that ways that you can accomplish this fairness in the process, and I'll refer to those a little bit as we go along. But generally, I wanted to start out with the example of the building a new elementary school. So competitive sealed bid process is it's a tried and true way of getting to an efficient and economical cost for building whatever the district needs, the elementary school. Over my career, I've represented, as well as government entities, I've represented general contractors, subcontractors, architects, and engineers, and all of whom have had, in some way, shape, or form, have had some involvement with procurement organizations, including the Charleston County School District. Fortunately, I haven't had anything with the Charleston County School District in quite some time. But my clients, just sort of full disclosure, Brantley Construction is a construction company that's been around a long time, and they've built a lot of schools. I'd also represented Dawson General Contractors, and they were the same. Emery Infinger, Ruscon, Hill Construction. Through my old firm, and I have represented a lot of them. And so when these companies they live and die by these competitive sealed bid situations. And so when they get word that there's going to be a new elementary school, they've got to get the invitation to bids. So what happens is the staff puts together through design professionals, the staff can put together a program with the design and specifications for what you want the school to look like, put it into a big invitation for bidders, a big package, and those go out to general contractors who want to bid on these projects. Now, this is it is as crazy a process as you can imagine. Inside, it's a sausage factory for a number of these general contractors, I think for all of them, because it is so time sensitive. Typically, it's, well, this bid is going to be opened on a Tuesday afternoon at 2 p.m. or Thursday afternoon at 2 p.m. And we're talking about building an elementary school. So it is just could be hundreds of different components that have to come together. And this general contractor, its job is to consolidate it all into one number that's going to charge the school district to build this school. So it's got to have roofing subcontractors and plumbers and electricians and air conditioning and landscaping and everything that you can imagine. So that's why I say it's a really hectic process because they've got all their numbers of telephone numbers of all these people who are putting in bids, and a lot of times it's 15 minutes before bid opening and they're still getting a price from one of their suppliers. So they finally get it, and they're able to rush. In some cases they still have to personally hand it to the bid opening official. So they're rushing out the door, and they'll seal it, and then there is a formal process by which the bidders show up, and say at 2 p.m. on a Thursday, and the procurement official goes through and unseals each bid. Says here's a bid for $3,902,000 and whatever dollars. Here's one for $17,302,000, and then but generally they're sort of bunched together. There's any number of bidders can put a bid in. Time was when you had 3 or 4 contractors in this area who were always going to bid on schools. As the economy goes up and down, contractors who once prided themselves in only building hotels and multifamily developments, suddenly they become interested in building schools because they need the money. Now that's not a bad thing, but that's just the way it is. So when they put together their bid, it's open. Generally speaking, the bid is awarded to the contractor who is responsible and responsive and has the lowest bid. And so responsible means it's meets the requirements of the invitation of bid. And so the district has some authority to set those requirements that, for example, if you're going to build an elementary school, we don't want somebody who has never had any experience building a school before, or we don't want anybody who's not otherwise qualified. So it can have a list of requirements. If and those in the bid, it has to certify that it meets those requirements. If it doesn't, then that bid can be discarded because that's not a responsible bidder. It's not that happens frequently because there can be, depending on the project, there can be some very specific requirements. Now, responsive is, did the contractor's bid actually meet the requirements of the instructions to bidders, the information for bidders? And those can be, 3 inches thick. And so that's a process that takes a little bit more time to go through the bid and make sure that if they were the low bidder, they're not the low bidder because they forgot to put in a whole wing of classrooms. So there's a validation process that occurs and a review of the bids after the fact. But at the end of that process, and that's where your excellent staff comes in, and they're experienced in carrying out this process. So they'll say, they'll go through and they'll certify, and then they give a notice of award to a particular contractor. At that point, you can have a protest by a second low bidder, somebody who was, $100,000 higher than the one who was actually awarded the project on a $6 million project, and that's pretty close. You can expect that to occur in a lot of cases because, again, this is a very competitive environment, even in the best of economies. But it's a lot of money for these contractors, and they employ a lot of people, and they not just employ a lot of people, but they engage a lot of subcontractors and that they work with. They've got a huge team, and so if they get a school to build, it sets them up nicely for their finances, and that's just the way it is. This is a competitive environment. So somebody who misses something by $50,000 or $100,000, they're going to be scrutinizing that low bid, and they're going to be going through it line by line. If there's something in there that they see is not consistent with the requirements, they're going to file a protest. Now, when they do file a protest, what's the good news there? Well, you've got what I always call a cookbook. Well, you just, if you say that there was something wrong with that process or with that awarding of that contract, you just go through and it says, if you have a protest, then you must file a written protest with the procurement official. An initial decision is made by the designated official in the code, a staff member. And then if you choose to take that to the next level, that's when finally we're getting to Lawrence's point about the review panel, which is a 5-member review panel. And I have done that. It's been quite a while, like I say, but that's a good process because it allows for board members, but also members of the community. So I think there is a board member who is the chairman, and then there are designees from among the community who are quote unquote experts in different fields that are required. So you may have an architect on the board, you may have an engineer and a contractor, or some other professional who knows what they're doing. And so I, as representing a contractor way back then, if I had a dispute, I would have a really good panel who could walk through this, and I could show clearly, okay, well, this is how I think that my contractor client was unfairly treated because he adhered to the requirements of the bid. The low bidder didn't, and so the award should be canceled and awarded instead to my client. If the procurement review panel of the district does not, so they'll issue a decision, and if that's against the contractor, they have the opportunity to appeal it up to the state procurement official, and then eventually it can go on to the circuit court. So it can be appealed up and up and up and up. So that I just wanted to give you the idea of where that panel sort of fits into the overall picture. Now, one thing that there are a number of different ways that the district can procure services and goods and construction projects.
And the one thing I'll add to that, there is a whole, I don't want to call it an underbelly of members of the bar, but there is a whole subset of lawyers within the South Carolina bar that are very familiar with what they perceive to be abuses in the procurement process. There's a gentleman out of the upstate in his public interest foundation who has made basically his individual mission and has created a trust fund to fund procurement abuses or perceived procurement abuses all over the state. And so there have been lots and lots and lots of case law that has been developed around these very challenges because of potential perceived abuses. And that's when Pat alludes to the fact that you have a very well-written cookbook. As long as you follow those practices and procedures, you're generally going to keep yourself out of trouble in the event of one of those challenges.
My question to you is, so that review panel would make sure that we're not awarding projects to our best friends or someone who we know, to make sure that we are doing what we're supposed to do as a district.
That's correct.
How do we go about getting that panel in place?
So, Dr. Fraser, I just want to clarify that the panel is in place for the review of protests by bidders. So it's not a panel that just sits and kind of monitors the oversight of the procurement process for the district. That does not exist. The panel is specific for bidders who have bid in a particular project and either were not awarded or think there was something wrong with the process, and they properly filed a protest with the district. That is what the panel reviews.
I can add something. The panel also oversees claims on issues that a potential contractor might have, subcontractor might have with a prime contractor. So they could express their claims or issues directly to the chief procurement officer.
So what do we have in place to make sure that the process is fair to all participants? Do we have anything like that in place for the district, or
We actually do.
that the board can implement?
Actually do. And so Article 21 of the Procurement Code, and it's not important that you look at it, but it's assistance to minority business enterprises. Let's just take that as an example. So that is a very detailed statement of how the district will follow South Carolina policies and South Carolina law to enhance. Well, let me read this. Let's see. The board therefore sets these procedures that will result in awarding contracts and subcontracts to minority business firms in order to enhance minority capital ownership, overall district and state economic development, and reduce dependency on the part of minorities. I mean, so that's stated right there in the code. And so when I said that this is an excellent document, it is in there. And so you should take some comfort that that there is protections in here, which we just need to follow. You don't need to sit up here and say, gosh, is this being done properly? Well, as long as you are again following the cookbook, then you should meet all of these policy goals. And so if, for example, there is some dispute by a minority business enterprise, a contractor who happens to be a second low bidder, just like I was saying, anybody could be. If he or she believes that there is some unfairness, or that somehow the procurement code was not followed in that bid process, that's the opportunity. File a bid protest, and you'll have a hearing, and you'll have the ability to appeal it up through the various levels.
But
May I ask a question?
yes,
Just as a follow-up to Dr. Fraser, I feel like the question she's asking is, do we have any sort of regular oversight that looks at what we're doing all the time? Kind of like we have a finance and audit committee. They're constantly watching to make sure that all of our finances are in alignment with policy and code. Do we have something specific to procurement that doesn't rely on someone saying, I've been done wrong?
I would say that would take place in our annual audit.
Yes.
Yeah, I would say that that would take place during our annual procurement audit. Each year, the code requires us to have an audit of our procurement. So that's done by an external outside auditor. And the purpose of that is to go through and review all our procurements to ensure that they were done in compliance with the procurement code.
Thank you.
I have a specific question. I have just happen to have the Charleston County School District Consolidated Procurement Code here, looking at it, and I highlighted section 540.2, which talks about the oversight by the Board of Trustees and that policy. And I just wanted to know, did you have that available there so you could explain that to me? Because it does say that the board shall consider and decide matters of policy within provisions of the code. So,
Well, I think that's right. And this is going to be a group answer, I think, but I'll start out by saying that, yes, ma'am, that I think that is, you're exactly right, that is in there, and the board does have some limited authority, subject to what Lawrence was saying, that remember, we're limited, the district is limited by the legislature, that you've got to follow the South Carolina Procurement Code strictly. And so, but within that, there are some limited ability to, or there's some limited ability to set policies and change policies and make sure that fairness is carried out consistent with the procurement code. But Natalie or Lawrence, you want to talk about that at all?
No, I think you're absolutely right, Pat. I think, Dr. Frazier, what it is that you're trying to, the question that you're trying to get at is kind of what is the board's authority under this code,
yes.
right? And
Ms. Ham, we can barely hear you. Can you speak into your mic? You're on mute.
so I am thinking as close to the microphone as I can possibly get. Is that?
It says you're on mute. Is that?
No, it's because I'm in the boardroom.
Okay.
I can't unmute my computer or there'll be feedback.
Got it. Okay.
I'm sorry, this is one of the new microphones
Yeah.
that maybe here.
Or Tay, you can use mine.
What I'll do, Ms. Ham, is just to make a copy of this, and then you could sort of like explain it to me, because I want to refer to specifically 540.2, oversight by the Board of Trustees regarding the policy. And then we can get together. I won't tie you up for time.
Right, I just want to make it clear that kind of as Lawrence and Pat have explained, that the board does have some limited oversight authority over certain policies and structures that affect procurement. But as a board, I won't even say limited, there's really not a role within the procurement process itself, if that makes any sense.
Yeah.
Yeah, so you still provide oversight because you're the person's, acting as a body whole that enacts this policy. The policy does not come into effect without the board taking action to approve it by thumbs up or thumbs down vote. And so again, you could make changes to this policy should you see fit. The problem is that you also then have to go up to the immediate level of review and scrutiny by the state to make sure that they agree and validate those changes. And so the current version of the code that you have adopted, which substantially conforms to the state procurement code,
Okay.
doesn't give you any oversight responsibilities over the day-to-day operation of procurement, other than appointing the members to this limited appeals review board.
So are we bound by the previous decisions made by previous board members?
Yes.
We are. Okay.
Yes, ma'am. And look, as an elected board, you can make a determination to change the decisions of previous board. Any of those policies that have previously been enacted, you've stated in your policy responsibilities that they will be regularly reviewed and updated, and changes will be made as necessary to implement the policy-making responsibilities and decision-making of this board constituted as a body whole. I say that against the backstop of procurement is a little bit of a different animal because of this additional level of state preemption in how procurement operates. But if you decided tomorrow that you wanted to change your procedural rules and you say, we no longer want to follow Robert's Rules of Order as our procedural rules, we want to come up with our own rules of procedure, there's nothing that stops that from happening. It takes a single resolution of this board to make that decision because you have the ability to implement policy and you have the ability to implement procedural rules affecting the day-to-day operation of this organization.
And Dr. Fraser, if I might, what I would recommend is that if a board member feels or has a question about a particular policy, and let's say the minority business enterprise fairness aspect of the code, if there's a question or a concern, or if you think there's a problem, or somebody's mentioned to you there's a problem, well, I'll offer myself to help you with that issue. That because what I perceive is that if the code is followed properly, there is fairness in it, and that's the problem that we have. I think with anything is we've got laws on the books, but they're just there's human beings involved, and sometimes it's not followed exactly as it should be. I think that your staff does, but if each board member or any board member has a concern, I think that might be the best way to handle it is to say, hey, where does it say in the procurement code in our policy that this is okay? Or, does that help at all? That because that would be relatively easy analysis.
Yes, well, I just want to ask you a question. Are you offering your services to me personally that I can contact you with a question? Or,
so at the end of the day, as lawyers for the district, we only represent the body whole. So
okay.
you would need to separately engage legal counsel to represent you in an individual capacity. We're here today as a representative of the full board, but if the full board said, we have a question about this, it came in front of you in front of a full commission
I just
meeting.
want to clarify that.
Yes, ma'am. That's a very
Yes,
good thing to otherwise clarify. You came back and you told the superintendent or you told your chief legal officer, yeah, we'd like a second opinion on this from Pope Flynn. Absolutely, that is a role that can be fulfilled. But personal responsiveness is obviously something that falls outside the scope of legal representation for someone that represents.
And again, that's good news because you don't have to do this personally. You're within a structure and you've got the ability, you've got a staff at your disposal. You work through the board and then you can get your answer that way. It's good news, I think.
Right. Many of those types of questions Mr. Wiltshire answers almost on a daily basis. Certainly when I have them, I
Actually, I have an example here that will maybe, if you look at that top bullet up there, it says competitive bidding not required on purchases under $2,500. Well, the Board of Trustees has established a list of exemptions for us to operate with. And those exemptions allow us to purchase goods and services that exceed the $2,500 threshold without competition. And I can give you an example. When we purchase goods and services that are student related, that provides direct services to students, those services are exempt from the competitive process. No matter the dollar amount, we can go out and purchase those services without competition. And that was something that was established by the Board of Trustees. And those exemptions are different from the exemptions that are in the state procurement code.
Okay.
And Dr. Fraser, you can find those particular exemptions. They're Appendix B to the draft that you otherwise have if you want a recital of all of those various appendices or the exemption. And kind of, I think maybe to put a bow on this kind of larger question of what is the response outside of the annual audit. Remember what Pat originally alluded to in the bid package. You're awarding the bid to the lowest responsible and responsive bidder. And so in making that analysis, being responsive and being responsible are basically the entire service purpose of your procurement officials, because they're looking at it to make sure that they can check all the boxes that these people have and that are submitting your bids, have all of the necessary criteria and qualifications in order to otherwise qualify. And the fact that they may have some internal interest doesn't necessarily disqualify. There's an ethics opinion that I think is a really interesting one out of the city of Columbia. The city put out an RFP for bond counsel services, legal services to serve as bond counsel to the city. And one of the firms that submitted a bid was the mayor's law firm. Well, the question was, well, can that service be procured by the city, or are they automatically excluded from procurement? Well, the mayor didn't have a vote because at the end of the day, he's not making approvals on procurement. When his firm submitted, they were making a determination based on the qualifying criteria of his firm. And they were ultimately awarded a bid, and it wasn't deemed to be a conflict because the mayor didn't have a direct oversight on it. And so anything that came in front of him, the mayor had to make a decision on. He was a partner in the law firm. He had a direct financial interest. He was not allowed to vote on it when it came in front of the board. But obviously that was not a disqualification so long as they were both responsible and responsive.
So I just want to kind of take note of time here. I know that Mr. Wilshire has a presentation that he wants to make with regards to the specific process for the district. So unless there are any otherwise extremely pressing questions for Mr. Flynn or Mr. Flynn, I would like to move to the next section, Reverend Mack, if that's okay with you.
And we'll
Yes,
stay
please.
here
Thank
and
you.
answer questions if
If anything comes up.
required.
Maggie, you want to give the presentation?
I think she's switching it for you now.
Good evening, good afternoon. My name is Wayne Wilshire. I'm the Director of Contracts and Procurement for the district. And I'm gonna give you a brief overview of the procurement process. What is procurement? What is the procurement process? Procurement process is the name for all the steps the district must take to acquire products and services necessary for the district to operate. Typically, a procurement process will start with a purchase request and involve steps like identifying the vendor, negotiating price, invoice approval, right through to receiving the products or services. Next step. Steps in the procurement process. There are 9 steps in the procurement process, and I'm going to walk you briefly through all of those steps. Next slide. Step 1. Step 1 takes place outside of the procurement office. The first stage in the process is to determine the need for a product or service. Schools or departments prepare a description of the products, services, or a statement of work, and they estimate the product or the service, estimate the cost of the product or service. As I said before, this takes place before it gets to the procurement department. This is a step that is done within the schools or the departments. Next step. Step 2, submitting the purchase requisition. The school or department, once they've identified their need and an estimated cost, they submit a purchase requisition to the procurement department via MUNIS. Purchase requisitions are approved by various staff based on the dollar amount of the requisition. Once the procurement staff receives the purchase requisition, they review it for the accuracy, description of the product or services, the source of funds, and the cost of the products or services. Procurement staff, based on the description, the estimated cost, determines the method of procurement, which I'll talk about a little later. Next slide. Assessing and selecting vendors. Procurement dollar amounts and methods of procurement are used to identify vendors and to select them through various types of solicitations. Next slide. Procurement dollar thresholds. From $0 to $2,500 requires no competition. $2,500 to $10,000 requires 3 formal quotes. $10,000 to $50,000 requires formal quotes, and we must advertise it. And over $50,000 requires a formal solicitation in the form of an invitation for bid or request for proposal. Next slide. Methods of source selection. The district procurement codes has various methods of source selections based on the goods and services that we're procuring. We will use one of those methods of source selections. Those that are often used in construction is Section 5220, competitive seal bidding, Section 5230, competitive seal proposals. Next slide. Section 1550, small purchases. And section 3015, project delivery methods are used for construction. Section 3220, architectural, engineering, construction management, land bank services. And section 3230, which is used for purchasing architect and engineering services that are not of a high dollar amount. Next slide. Negotiating price and terms. Once the vendor is selected, the procurement staff will negotiate the best price and specific terms for the procurement. Next slide. Once we've negotiated price, procurement staff processes the purchase requisition into a purchase order and submits it to the vendor. A purchase order is sometimes supported by a formal contract, and this is necessary when specific terms and conditions are not included on the purchase order and are required to reduce risk and liability. Next slide. Step 6, receive and inspect. Once the product or services are delivered, the receiving school or department will receive and inspect the services. If the goods or services are not acceptable, they will reject and return it to the vendor. Next slide. Next, step 7 is conducting what we call a three-way match. During this stage of the process, the procurement staff, school or department, and accounting will use 3 key documents to ensure that the transaction is accurate: the purchase order contract, the packing slip, and the vendor invoices. Those 3 documents has to match up in order for us to complete and pay that invoice. Next slide. Step 8, approve invoice and make payment. School or department approves the invoices and notifies accounting, who processes the invoice and issues a payment via a check or direct deposit. Next slide. Step 9, the procurement staff must maintain proper records for auditing and reporting purposes. This means saving all relevant documents for every completed purchase. And normally we maintain those for up to 20 years. Next slide. We're going to walk you through briefly how we procure construction and maintenance services. Section 1520, competitive seal bidding. Contracts greater than $50,000 must be awarded by competitive seal bidding, except as otherwise provided in Section 1510, methods of source selection. During this process, the bid documents, plans, and specifications are submitted to the procurement officer, who takes those specifications and put together and issue an invitation for bid. Then the notice of the bid must be published in the South Carolina Business Opportunity SCIBO, and also now we've started using the Charleston Chronicle to advertise our construction solicitations. Bids are sealed and submitted to the bidder by the bidder to CCSD, and then there's a public opening of the bids. Next slide. Statement of award or notice of intent to award are posted on the website. Based on the dollar amount of the award of this procurement, we'll issue a statement of award. If it exceeds $100,000, it'll be a notice of intent to award. Statement of awards allows us to go directly to the vendor without a 10-day waiting period. If it's over $100,000, we have to issue an intent to award and wait 10 days to see if there's a protest of the award. Once the 10-day protest period ends, the contract notice to proceed is issued and they can start work. Next slide. Small purchases, 1550. Small purchases not exceeding $2,500 must be accomplished without securing competitive bids or quotations if the prices are considered reasonable. Purchases over $2,500 to $10,000 requires a minimum of 3 quotes, whereas a purchasing officer can pick up the phone, call up a vendor, and request a quote, and then move forward with the procurement. Purchases over $10,000 to $50,000, formal solicitation of written quotes, bids, or proposals are required. Next slide. Next slide. Section 3220, pre-qualifications of district constructions. As Pat mentioned, a lot of our schools, they're big projects, and we use this pre-qualification process to ensure that we have qualified vendors. That's been a process that we've used quite a bit in the past, and we're really going to take a look at that in the future of our use of the pre-qualification process. Section 3220, qualification-based selection procedures used for architect and engineering services. construction management, and land surveying services. Here, the district establishes what we call a selection committee. This selection committee consists of people that are appointed by the superintendent and various people throughout the district who has knowledge of the different projects and stuff that the district has engaged in, becomes a member of that team. That team, they develop the project scope, they prepare the formal solicitation, they interview and evaluate firms, they select and rank the 3 most qualified firms, and the procurement official negotiates with the highest ranked firm. Next slide. Section 5240, Minority Business Enterprise Plan. This plan here allows us to work with minorities in a manner that can help us increase our goal. Well, the purpose of this plan is to establish the use of minority businesses, develop a plan annually, establish an MBE goal, submit reports annually to the board on MBE participation, and negotiate directly with certified South Carolina minority businesses. An example of the use of this process, we have negotiated directly with Construction Dynamic Incorporated to build Hot Gap Extension. This is an estimated project of about $6.8 million. And we were able to negotiate directly with them because they are a certified South Carolina minority business. Next slide. I think that concludes my presentation. Are there any questions?
Yes, I have a question. This is Dr. French. You mentioned earlier there are some exceptions to when we have to use specific parts of the procurement process when it comes to student services. Could you give some examples so we better understand why that exemption was made?
Well, that exemption was made by the board. When we're purchasing certain student services, time is a factor, and there are things when you're going to come in contact with students, we got to be very careful who we are opening up, coming into meeting with our students. So we got to be very selective of those vendors who work directly with our students. So in order to do that, those services were exempted from the competitive process. Therefore, if we did that in the competitive process, we may end up with someone that may be questioning that. And you don't want that when you're dealing with students.
Right. I guess that because you said there were no limits in terms of how much it would cost. I mean, you wouldn't ever say, okay, this construction project is for student services.
No.
And I just
very specific of what
I just wonder what the parameters are.
It's very, very selective of what those services are. In the procurement code, at the very end, I think it's Appendix A, it lists the various exemptions that the board has established.
I have a question, Mr. Roger.
Yes, ma'am.
You mentioned that there was a committee appointed by the superintendent to oversee some of these procurement processes. Could you explain that?
There's a committee that is there to select architect and engineering services, construction management services, and land surveying services.
So is the board involved in that process or just the superintendent?
The superintendent designates a person that permanently sits on that staff, which is a procurement officer. And the procurement officer then selects the people who are on that committee.
Where are we with the small business, MBE and SWE? You know, that process, and we were supposed to be getting some people to come in and tell us a little bit about that process. Where are we with that process now?
Dr. Frazier, I'll respond to that question. So at the end of January, when we had the, when Representative Gilliard had the MBE forum, I agreed, suggested, and agreed to form the committee that you're speaking of. That committee has been meeting once a month. I think we've had 3 meetings. The next one, I believe, is next Wednesday. And so, so that committee is looking at internal processes that we use to identify the use of minority firms, and that committee will make recommendations that I will take through the Audit and Finance Committee. So that's one aspect that's happening, and the other aspect is that I briefed the Audit and Finance Committee as well as the board that we have submitted an RFP for a disparity study for a firm to come in, take a look at the district's procurement processes that they relate to available minority firms and our utilization of minority firms, and give us specific recommendations if there are gaps in those two data points, the availability of firms versus the district's utilization of those firms.
Will they be in place before we start on phase 5, Mr. Kennedy?
So, planning for phase 5 has started, but we're at the very beginning point of phase 5. So yes, they will be in place well enough to be able to have an impact on phase 5 construction.
So they will be included, is that what you're saying?
That is correct.
Okay. And I have one last question about the construction management firm. We've had the same firm for 20 years. Is that law, or how do we continue to have the same construction management firm for a number of years? And is there a law that would prevent the district from maintaining the same firm?
I think
for
when I
another
was,
time?
I think when the first time I was here in the district, I think and Wayne, you can correct me, I think we had 2 construction management firms at that time. When I came back 3 years ago, we had the single firm that you're mentioning. We will be going out for with a competitive procurement process through an RFP for the construction management firm. We're actually looking at bringing in more than one construction management firm. For
We will have more than one.
So we're looking at that now. Yes, ma'am.
Thank you.
But
And we're also looking to use that minority exemption to work with a construction management firm too.
Very good.
Yep.
I'm very pleased with what I'm hearing today. Mr. Welcher, I would like to have, I am a hands-on person, old school. Is it possible that I could get a copy of your presentation?
Yes, ma'am.
Thank you, sir.
Mr. Wilcher,
Yes, ma'am.
it's Dr. French again. I mentioned, you mentioned this pre-qualification process and that's going to be reviewed. Is part of the reason for the review to see whether there are any unnecessary barriers that might prevent minority businesses from being able to get into to get good bids for the district?
Yes, ma'am. Yes, ma'am. That is one of the reasons, but also we just want to look at that process as it impacts not only minority business, but it also impacts other local businesses within the state.
Okay, good. That's good to hear. Thank you.
I have one more question. I'm not going to ask another question, I promise. Mr. Welcher, I guess this is your question. When we talk about contracting for services, school-related services, are we talking also about hiring minority persons to come in as consultants? Or is that something that you handle through your department also? Because I'd like to take a look at whether the district is being fair in bringing in consultants for school-related kinds of events.
I think if you look at the SWMB report that went out this past year for FY20, you will see that we broke out our purchases into several categories. We focused on maintenance and repair, construction, IT, and academic related purchases. And within the academic related purchases, you will see that we focus on minority consultants that
that focus and impact the schools.
Does anyone else have any?
Good afternoon. I do have a quick question. Is that in reference to like mentorship programs or after-school programs as well?
I didn't quite
I
understand.
think she said, is that in relation to mentorship programs?
Yes, yeah.
Yes, ma'am.
Thank
The response was yes. I just want to make a note for the benefit of for all the board members present that after the workshop today, we'll make sure that the superintendent's office gets copies of both presentations and a copy of the consolidated procurement code that will be updated to board docs. And obviously, we'll get a printed copy for Dr. Frazier. And if there are any other questions, both Mr. Flynn and Mr. Flynn are still here, and Mr. Wilshire is available. So unless there are any other questions, I'm gonna go ahead and wrap it up.
I'd just like to thank you for bringing forth this session for a new board member. I am very interested in this process. And my constituents are interested in this process. And hopefully we're going to be as transparent as we can, because there's a lot at stake when it comes to our reporting back to our constituents about what's going on in the district. So I just want to thank you for bringing forth a team to talk with us. Mr. Wiltshire, Mr. Kennedy, thank you all for taking the time. Dr. Postlethwaite, thank you so much. This has been very informative and I appreciate that.
Reverend Mack, I'm gonna turn it over to you.
Okay, all right. Thank you to our presenters today for the presentation, and Ms. Ham, thank you for coordinating this workshop for our board members on today. If there are any follow-up questions, I do ask board members that you submit those to the superintendent's office, and we will get those answers back to those questions. The reason why I said the superintendent's office is right now, Ms. Ham's last day is on Friday, tomorrow. So she will no longer be with us. So we will definitely miss her. But just so that these message or questions do not get lost in the shuffle, we ask that you submit those to the superintendent's office, and we will definitely get answers to those questions as soon as possible. So again, thank you to everyone for this presentation on today, and we say to you, have a good afternoon.
Thank you.
All right.
Thank you.
Thank you.